enough evidence to go to trial. Larry Millete will be tried on 1 count of murder.
Criminal defense attorney David P Shapiro joining us now with more on what's next. David, good morning. Thanks for joining us again.
Good morning. Thanks for having me.
I don't think anybody was surprised by this, but this was a 10-day preliminary hearing. Trial now set for September 14th. Was this normal to have 10 days for a case like this?
Well, I mean, this case like this is not normal, and that's the first step, right? Usually in a homicide preliminary hearing, you're looking 1 day, 2 day, 3 day, but a case like this was so unique, and it was so unique primarily because they don't have a body. So the prosecution had to spend a significant amount of time on proving that Ms. Maletti would not have just disappeared, would not have just abandoned her kids, would not have just abandoned her family, friends, finances, so on and so forth. And that's where they focused so much of their attention, because the motivation, the desperation of her husband was clear. That was easier for them to prove, but they did spend a significant amount of time, significant amount of days proving that she would not have just disappeared.
And in those days, we saw a lot of evidence being presented, a lot of witnesses. It almost felt like it was already a trial. So in a case like this, if the actual trial starts September 14th, how much more evidence is being withheld for the actual trial that we didn't see here?
Well, a couple things. First, for preliminary hearing, obviously the burden is so low compared to what the burden is at trial, so the prosecution does not need to put everything forward. In all likelihood, they gave a pretty good summary of everything they have. Now, if something were to come up between now and September, or whenever this trial actually goes, that's a different story. It's going to be a lot more in-depth, though. So a preliminary hearing that would take 10 days would probably lead to a trial that would take at least a month, if not longer. That's not even including how long it would take to pick a jury in a case like this.
Would they have held anything back, anything more powerful than we've already seen for the actual trial?
I would not expect them to do so, especially because, listen, I mean, the preliminary hearing burden, again, is so low. Most everyone knew that they were going to get past this past week and get this case eventually to trial. Anything major they would have put forward. There may have been other things they might still be working on. It's still an ongoing investigation, but I would be surprised if they didn't put their best foot forward these past 2 weeks.
People observing this case closely have noticed, they've been somewhat critical in the legal circles, at least, of the defense attorney and how maybe they approached the case. Does he keep the same attorney? Does the defense have to change their approach once the trial starts from what we saw here?
Sure. Well, one of the things that any defendant at or soon after a preliminary hearing really needs to assess is who's going to be standing by him or her if the case proceeds to trial. And that's whether you're dealing with a low-end felony where in all likelihood you're not going to get any jail time, or a case like this where inevitably he's going to spend the rest of his life in prison if convicted. And one of the things you need to really assess is, do I feel confident that this is the best option, this is the best defense team for me? That's something Mr. Meliete really needs to be thinking about moving forward. The other portion of it, I mean, looking what the defense may have learned from it, I think that, you know, sometimes it's best to have a more concrete approach, even at a preliminary hearing. Really focus on what the issue is and what the issue is not, as opposed to throwing everything against the wall, asking way too many open-ended questions, you know, and then it shows that you don't necessarily have confidence in your defense and you're just hoping to sort of stumble into something. Not usually an effective approach. Yeah. Don't think it was super effective in this case either.
Raul just mentioned that Maya's body still not found. How does that work legally in a case like this when you don't have a body?
Sure. Legally, it's not required, and the judge and the district attorney went to great lengths yesterday to talk about how there's certainly been plenty of convictions, well-known convictions in California, even some here in San Diego where the body was never found or certainly was not found through the trial. But it is a gigantic step because one of the key elements of a murder is that someone is actually dead, and where they have a significant amount of circumstantial evidence that Larry Millete had reeked of desperation, reeked of fear, panicked, was losing his wits as it relates to potentially losing his wife and losing his family. What they have yet to put forth is any evidence on if he did do it, how he did it, and where he did it. And that's really important, and that's going to be an obstacle the prosecution's got to get past if they're going to get a conviction at a jury trial.
What's your top 1 or 2 strategies if you were the defense attorney in this case? Because it seems like you can go in a number of directions in terms of the approach, but what would your strategy be in something like this?
Well, here's the thing, right? There's many ways you could look at it. Well, one, you could make the argument that, well, they haven't proven to you, they being the prosecution, has not proven that she is in fact deceased. that she could have just ran off. Now that's going to be an uphill battle because based on what we saw the last 2 weeks, it is pretty likely, if not extremely likely, that she is no longer alive and she would not have just run off, right? So that's a strategy decision the defense needs to make. Secondarily, though, even if she is no longer with us, even if she is deceased, there are so many defenses within that necessarily do not always have to point at Larry Millete as the person who did it. You know, was he the person who did it? Maybe, maybe not. Was he the person who knew about it? Maybe, maybe not. Did he do it, and was there a viable legal defense, self-defense? Who knows? But I think at some point, I know at some point, they need to hone in on a strategy and they need to stick with it, because this approach of, you know, asking way too many open-ended questions about spellcasters and all this stuff certainly didn't work the last 2 weeks, and the fear is it's not going to work at trial.
And it's not going to get any easier with all eyes on this case when the trial does get underway in the fall. David Shapiro, thank you as always. Appreciate the insight.
My pleasure. Thank you.
Thank you.